Hey everyone, and welcome to this explainer. Look, if you are a law student staring down a final contracts exam right now, you know exactly how convoluted the rules around third-party beneficiaries can feel. It's one of those dense, doctrinal topics that absolutely haunt students. But don't worry, because today, we're going to clear that fog. We are taking this textbook nightmare and turning it into a totally accessible, practical playbook. We'll update your understanding based on the modern restatement standards and give you the exact framework you need to spot these issues and completely ace your exam analysis. Let's get into it.
Okay, let's kick things off by establishing the historical villain of our story, and that is the ancient doctrine of privity of contract. For centuries, you guys, this doctrine acted as an impenetrable brick wall. It basically stated that a contract is a strictly private undertaking, meaning if person A and person B make a deal, person C is totally locked out. Even if person C was explicitly supposed to get something out of that deal, the wall of privity kept them from enforcing it. It was incredibly rigid.
But, as we know, the law isn't static, right? To get past that wall, the law evolved some heroes, or exceptions. Now, historically, under the first restatement, you had to fit the outsider into these super rigid little boxes, like a donee or a creditor beneficiary. But modern courts eventually recognized that this was just way too stiff. So the second restatement completely updated the standard to a much more flexible test. The new question is simply, did the original parties intend to confer rights on this third party? This massive shift from strict categories to manifest intent is literally the cornerstone of your modern exam analysis.
So here's our roadmap for the explainer today. We'll start with the wall of privity, move on to intended versus incidental beneficiaries, cover the key landmark case law, test your legal knowledge with some hypos, and finish up with a guide on acing your law essay.
All right, Section 1, the wall of privity. When you are staring down a contracts textbook late at night, you're usually hit with pages exactly like this. Just dense walls of text establishing that fundamental tenet: a contract is a private undertaking. And traditionally, the common law said it's highly unusual for anyone other than the contracting parties to have any cause to complain about a failure to perform. But here is the trap most students fall into. They get completely lost in the legalese. So let me translate this doctrine into 3 really simple takeaways that you can actually memorize. First, outsiders start with 0 rights, period. Second, exceptions had to emerge for purely practical reasons. I mean, think about life insurance for a second. If the beneficiary can't sue after the insured dies, the contract is literally useless. And third, modern law cuts through all those old clunky rules by focusing intensely on the original party's intent.
Moving right along to Section 2, intended versus incidental beneficiaries.
Now, as we touched on, the second restatement completely changed the game here. It tells courts to just drop those old creditor and donee labels as strict requirements. Instead, it asks courts to look at the objectively manifested intent of the promisor and promisee. Basically, did they intend to give the beneficiary the right to enforce the performance?
So, the absolutely crucial point you need to understand is this comparison. If the parties explicitly meant to give you a benefit, you are an intended beneficiary, and you can absolutely sue. But if you just got lucky by being nearby, say the city builds a gorgeous new park right next to your house and your property value skyrockets, you are merely an incidental beneficiary. You just got a secondary advantage. So if the contractor breaches and doesn't finish the park, you are out of luck. You have no right to sue.
Let's jump into Section 3, key landmark case law.
To really grasp this for your essays, we need to see how the rules evolved over time. We actually start way back in 1677 with Dutton, which was a family dispute over timber that bypassed privity because of quote-unquote natural affection. Then we jump ahead to 1859 with Lawrence, move to 1918 with Seaver, and finally land in the modern era in 1961 with Lucas. Okay, the foundational pillar in American law here is Lawrence versus Fox. The facts are super simple. Holly loans $300 to Fox. In exchange, Fox promises to pay that $300 to Lawrence because Holly owed Lawrence money. Makes sense? But when Fox didn't pay, Lawrence sued him. Fox argued, hey man, I don't have a contract with you. But the court actually shattered strict privity here by allowing Lawrence, who was a creditor beneficiary, to sue Fox directly. This officially aligned the law with manifest justice and commercial reality.
But, of course, courts didn't want limitless liability. So just a few years later, Vrooman versus Turner created a really strict limitation. In a case involving a mortgage assumption, the court held that you need a privity of obligation. Basically, there must be a clear, pre-existing legal duty linking the promisee to the third party before that third party can sue. This was designed to prevent random downstream promises from creating unexpected liability for total strangers. And then we have the incredibly emotional case of Seaver versus Ransom. Picture this. A dying woman wants to leave her house to her beloved niece. Her husband, who happens to be a judge, says, "Just sign the will leaving it to me, and I promise to leave the niece the equivalent value in my own will." The wife signs it, she passes away, and later the husband dies without leaving the niece a single dime. Outrageous, right? The niece sued his estate and she won. This firmly established the rights of a Donny beneficiary, proving once and for all that equity and moral obligation will overcome a technical lack of privity.
All right, Section 4, test your legal knowledge. It's Socratic method time.
Here is your first exam hypothetical. Think about this one really carefully. We have a municipal contract, a public benefit, and a catastrophic loss. If the water company breaches its contract with the city by having terrible water pressure, can the individual homeowner whose house burned down sue the water company directly? What do you think?
Well, the answer is no. Based on the famous H.R. Moach case, the citizen is merely an incidental beneficiary. Chief Judge Cardozo explicitly stated that allowing the suit would expose the contractor to a crushing, overwhelming burden that bears absolutely no proportion to the reward. So unless the contract explicitly states it is for the direct liability of individual citizens, the public is generally considered incidental.
Okay, let's try another one, this time regarding professional services, specifically estate planning. An attorney completely messes up the rule against perpetuities while drafting a will, and the heirs lose out on their inheritance. Can those heirs sue the attorney for breach of contract, even though they never signed an agreement with that lawyer? Take a guess.
Yes, they absolutely can. The California Supreme Court, in Lucas v. Ham, recognized that the main driving purpose of the testator hiring the attorney in the first place was to effectuate that specific future transfer to the named heirs. Think about it. If the heirs can't sue, no one really can, because the deceased person's estate hasn't actually suffered the exact financial loss. The heirs are the ultimate intended beneficiaries.
Let's try one more, focusing on construction projects and statutory requirements. The Illinois Bond Act requires public projects to have a payment bond. If the housing authority forgets to get one from the general contractor and a subcontractor goes unpaid, can that sub sue the housing authority as a third-party beneficiary of the contract to procure the bond?
The answer again is yes. As the court held in Western Waterproofing Company, a payment bond is, by definition, specifically designed for the protection of subcontractors and material men. Because the primary intent of that specific clause is to protect them, making them intended beneficiaries, they absolutely have the right to enforce the obligation.
All right, let's wrap this up with Section 5, Acing Your Law Essay.
When you inevitably get a third-party question on your exam, do not panic. Just use this exact IRAC method. Step 1. Identify the outside party trying to enforce the deal. Step 2. Lay out the second restatement definitions, making sure to clearly contrast intended versus incidental. Step 3. Apply the facts. Compare your fact pattern to Seaver if it's a gift, or H.R. Moch if it's a municipal contract. You're hunting for manifest intent. And Step 4. Make a definitive conclusion on whether they have standing to sue.
I'm going to leave you with this final, provocative thought for your next study session. Knowing how easily third-party rights can now be implied by a court that's just looking for intent, how explicitly do you need to draft your future contracts to protect your clients from surprise lawsuits by strangers? Seriously, as a future lawyer, sometimes the absolute most important words you draft are the ones stating exactly who cannot sue. Keep that in mind. Thanks so much for joining me on this explainer, and good luck crushing your exams.